the legal steps when it comes to defaulting tenants, and particularly dealing with the default and their subsequent eviction from the property. It's a relatively simple process, but obviously for those that are accustomed to the process. For those that aren't, it may seem very complex, and there's often debates around the complexity and whether the complexity is actually necessary. So in lease agreements, the lease agreement basically it gives lawfulness to the occupation. So you as an owner have the right to occupy a property. However, by virtue of the lease agreement, you are giving this right to somebody else. So now this person carries the right to occupy the property, and you as a landlord no longer have that right. We can all agree there. That's the lease agreement. So the only way to have someone get out of the lease agreement or the lease agreement get terminated is by terminating the lease agreement. If a tenant is in breach of the lease agreement, you then follow the steps to termination. Now, termination in South African law, especially if it's an investment property, more often than not, 90% of the cases, the Consumer Protection Act would certainly apply. The Consumer Protection Act requires that if the supplier, in this case a landlord, Section 14, would have to give 20 business days notice. Now, by notice, it basically means that you need to tell the tenant of your intention to cancel and afford them the opportunity of rectifying the breach. So 20 business days to pay the rent, failing which you're going to cancel the lease agreement. So that's the most common step, and short of situations where there's a serial defaulter. Let's just look at the one situation where there's been one incident of failure to pay rent and now the potential cancellation. So that notice goes out, gives the notice to the tenant. If the tenant still within those 20 business days does not pay the arrear rent, a second notice goes out. Now this notice is the notice of cancellation / vacation. So what does that mean? Your occupation of the property is hereby lawfully terminated. So that just basically means the lease agreement is no longer in place. So any occupation after the fact is now unlawful. The second request in that letter, the same letter, is please leave the property. So that just confirms that the lease is over and you're expected to leave and that your continued occupation is unlawful. So it's quite intuitive. Send out a notice saying, I'm going to cancel if you don't pay. And the second notice goes out, well, you didn't pay, so I'm hereby canceling, get out, right? So that's the pre-litigation step, right? You can do this yourself. There's a lot of systems that assist you in doing this. Our website, for example, has a free letter of demand that you can send out. Otherwise, approach an attorney like BSA Law and we'll do it for you. Now, that's the pre-litigation step, and this is something within the control of the landlord. The step after that is when it becomes the legal step. And this is unfortunately where we explain it as lawyers so that the landlords understand it, but it's never a process that the landlord is going to undertake himself. So we try and explain at a level that the landlord is simply just aware of what it entails, how long it entails, and what the costs are. And this is the eviction step. So as with any court proceedings, you basically go to court and you issue papers. What does that mean? You prepare papers. The papers have your grounds, your legal claims. You go to the court gives you a case number, and it officially becomes papers before the court. In order to institute this properly, you need to serve it. What does serving mean? Bring it to the attention of the occupier. And this is done, again, by virtue of the rules of court, by way of a sheriff. Right? So you go to court, issue the papers, get a case number, have somebody that's called a sheriff, which is an official of the court, give those papers to the tenant. And I can almost assure you, in about 70% of the cases, the tenants will move out at this point. Because in terms of lease agreements, a tenant doesn't have any interest in approaching a lawyer and fighting and paying money. So at this point in time, the tenants typically say, you know what, I'm out, I'm leaving, right? And you as a landlord can decide whether you want to collect rent or whether you just want them to pack up and leave, which is often the most acceptable route. Now, in the very few cases where the tenant does not vacate the property upon receiving basically that application from court, This is the step that always confuses people. So instead of the logical next step being, well, I go to court and I ask the court to give me an order making him leave, right? Unfortunately, in eviction law in South Africa, there's one little step that falls in between, and we normally call this, in our case, phase 3. So phase 1 is pre-litigation, phase 2 is issuing papers and serving them, phase 3 is going to court and asking the court to confirm or authorize a second notice to the tenant, giving them...
Just a minute, while you are there, at the stage of going to court, can I, as the landlord, do so by myself, or I need an attorney to represent me to do that on my behalf?
Because of the nature of the process, it's normally advised that an attorney be approached, because there's many legal nuances, requirements, things that we obviously do. Remember, as the law develops, more and more requirements come into place. So in the past, it used to be a question of simple things like inform the municipality that you're going to do an eviction. Then a court came along and said, well, it's not just about informing them, it's about including them. Okay, then we started including them in the papers. Then another court came and said, well, it's not enough that they're included, they have to engage. So now we have to force them to engage. Then another court came and said, well, the engagement seems very generic. They should engage, but on a bespoke basis, very, very particular and subjective to this tenant. So now we had to go. And so as the law develops, unfortunately, more and more legal requirements come into play. Even though the Act hasn't necessarily changed, the expectations on the landlord has changed. Now, doing it yourself is certainly possible. No one stops the landlord from doing this themselves. But unfortunately, this type of law has a lot of requirements to it, to the end that we have many attorneys that are our clients that practice in other fields of the law but do not really want to try their luck at evictions because of these type of requirements. And I mean, in the same breath, it's the same reason why I don't do RAF work, because there's a lot that goes behind RAF work that they know better than me. And I'm more likely to mess that type of work up because I don't know enough. In the same breath, they're more likely to mess up an eviction because they don't know that type of work. So for a landlord that has no legal background, that more so. And although the courts are helpful and may assist the landlord, it's only to a certain degree, because in the same breath, now the tenant's going to need assistance and the court cannot be biased. I would strongly suggest that an attorney be approached that specializes in evictions, but each to their own. It's obviously the landlord's right to do it himself if he so wishes. So the first section is just wrapping up the eviction process so that people understand where the costs actually come from. Because we stopped on phase 3, which was go to court and ask the court for a special permission, something that doesn't happen in any other type of litigation, where you actually need to ask the court for a special permission on how to serve another notice on the tenant. The reason this exists is to avoid homelessness, and especially to render people that are homeless and that might not understand the legal process and might not, may not fundamentally even know it exists, to be advised properly. This specifically happened in situations where there's many tenants, and the court needed to make sure that all the tenants became aware of this. But it is a process in our law. So unfortunately, before we go to court for the final order, we do have to go to court in the interim just to get the court to approve how we've served the papers and to give one final notice of the final hearing date. And followed by that is obviously the hearing date, where you ask the court for an eviction order. And it's only upon acquiring this eviction order that one can then proceed to instruct the sheriff to evict. So up until this point, you're not allowed to evict until the court has granted you an order. So that is the eviction process in a nutshell.